Patricia Van Haren, family law attorney. What happens when a spouse fails to disclose all of their assets during a divorce case? Clients have come into our office after the time that their judgment has been filed with the courts and their divorce is final, and they've discovered that there were assets that were not included or listed in their final divorce documents. These clients want to know what their legal remedies are and what we can do about those assets that they were not aware of during the divorce process. There's a case known as Marriage of Rossi, which explores this very issue. In this case, one of the spouses had won the lottery. However, they did not disclose this to the other spouse. Once the spouse learned about this fact, they brought that to the attention of the court. The court determined that as a penalty, the entire lottery winnings should be awarded to their other spouse. Ordinarily, each spouse is entitled to 1/2 of all community assets. However, in cases where one spouse attempts to hide assets from their other spouse, they could be ordered to give 100% of those assets to the other spouse. Additionally, items that are left out of the judgment are still under the jurisdiction of the courts. Therefore, if you discover that there are certain assets that were not disclosed in the divorce process, we would first make an attempt to meet and confer with the other side to see if there is a way to resolve the matter prior to going to court. We will be required to tell the court that we made an attempt to meet and confer, and our proof of this could enable our client to be paid attorney fees in addition to their share of the hidden asset. If we are unable to resolve the matter outside of court, we would then file a motion with the court to set aside the judgment based on fraud. Once the court rules on the motion to set aside the judgment, we would be able to obtain our client's share of the hidden assets, or possibly to request that our client be awarded 100% of that asset. We had a case where the husband had purchased properties for a second business that he opened with community funds. He did not disclose a second business during the divorce process and only listed the business that our client was aware of. When our client learned that there was another business that was earning even more money than the business he disclosed, we were able to reopen the case. We filed a motion to set aside the stipulated judgment based on fraud. We were also able to perform additional discovery and ascertain what financial accounts and property titles there were owned in the name of the other business. Our client was able to obtain additional spousal support, as a previous spousal support award was based on the cash flow of only one business rather than two. The court further awarded attorney fees and costs to our client due to the egregious behavior of her spouse. When discovering that some assets have not been disclosed in the divorce process, it is important to gather all information that you can about those assets. We may wish to hire a forensic accountant to do a full analysis prior to filing our request for order or motion to set aside the judgment. If you have any questions or require any additional information, shoot us over an email or give us a call.